3.
That's about 6 people.
And Laura Yaki, Assistant Public Defender, with and on behalf of Ms. 3, who's approaching. Ms. 3, could you say your name for the court?
Absolutely.
So, Your Honor, within the last couple days, Ms. 3 has sought an assessment for treatment. She completed the assessment. I have the paperwork here. I have the letter here. Based on the assessment, she's been recommended to participate in the intensive outpatient program through Henry Ford Health. Again, I have this documentation here. She is scheduled to attend individual treatment on the 2 days that she's not doing her intensive outpatient program, which is scheduled for 3 days per week. Additionally, Ms. Fleet is doing meetings every single day as a part of her recovery. I would ask, Your Honor, obviously the bond violation is very concerning, is very serious.
Okay, yeah, go ahead. I'll listen to everything, but
I would ask if the court would consider converting her SoberLink to a scram tether to ensure that she's getting 24/7 supervision, monitoring to ensure she's not drinking.
Jackie, you do realize that not only did she blow numbers, but then decided to have someone else blow into the machine for her.
Yes, Your Honor. There's no minimizing. There's no excuse or justification. The only thing I can do is present our plan moving forward, which the therapist has a psychiatrist. She does have mental health diagnoses, so she does need medication. She has her psychiatrist she's working with. She has her therapist she's working with. It took her a minute to find the right treatment to address the needs that she has. She is a single parent of 2 kids. They do rely on her tremendously. One is 3, one is 13, I believe.
So even worse, she had a 13-year-old blow into the machine?
Well,
I didn't ask her. She's free.
Oh, whoa. Is that what happened? Be careful how you answer it. I don't know that there's a good answer, but you better be careful how you answer it. Because I don't know which is worse. You telling me that, yes, is that what I did, or you lying to me?
I at this time, Your Honor, I'm asking if the court would convert her to a scram tether and mandate that she
drank and then had a child blow into the SoberLink.
I understand that's what the violation report says, Your Honor. And
does she admit to that violation or not?
The prosecution isn't mincing words. A .258 BAC, a crashed car, and a history of DWIs. This isn't just about a bond violation, it's about public safety. The state's argument is simple. If she can't follow the rules on a monitor, how can she be trusted in the community?
I mean, if she wants a hearing, we'll have a hearing.
I understand. May I have a moment to verify with her, Your Honor?
Yep.
Your Honor, may we briefly approach?
I don't know what good it's going to do, but you can come on. Reflect, we've had a bad conference in this case. You're supposed to say, Michelle.
The only other thing I wanted to request that I forgot to mention at the Ben's conference is if the court is inclined to revoke her bond, I would ask if there's any chance the court would allow her to be released to an inpatient.
The defense pulls the trauma card: domestic violence survivor, single mom, mental health struggles. It's a powerful narrative, but the judge has heard it before. The real question: can treatment override the risk? The prosecution's not budging, and the judge's patience is wearing thin.
treatment program with the tether, as clearly the root cause of both the underlying case as well as the bond is an issue of substance use. Again, she has dealt with enormous trauma. She's a survivor of domestic violence. She left an abusive relationship where her ex was convicted. And I think in November or shortly before December, which is the alleged defense date here. So there's a lot of circumstances surrounding here. Understandable that the court and the people are concerned for the community, but I would ask that this not be a case just held in jail without the opportunity to get inpatient treatment.
Ms. Feltes.
Your Honor, the people at this time would request the court revoke the defendant's bond and do not grant her a release to treatment. The underlying offense in this case is an operating while intoxicated third offense. Her priors are from 2011 and 2016. In this case, there was more than one call to the police reporting the defendant's bad driving behavior. She was eventually located by Michigan State Police troopers crashed. And when they had contact with her, she admitted to drinking. Eventually, a search warrant was obtained for her blood, and she was found to have a blood alcohol content, of 0.258. She was incredibly intoxicating, putting the community at risk, and is now drinking on bond. And as the court correctly pointed out, having a 13-year-old child flow into that sober link. I do not think she is in a position where she's capable of making good decisions, and I do not think that she is a risk the community can tolerate. I'm asking the bond, hold her without bond, deny her a release.
Anything else, Ms. Carter?
Your Honor, the only other thing I would say is I do think it would be adequate to protect the community if she's not driving, if she has a scram, if she's in treatment, especially if she can't leave.
I can't trust her. I'm just going to be upfront. It is going to be very hard for me to trust somebody that this court releases on a sober link, can't comply with the sober link, drinks, and then to try to save herself because she knows she has to do the confirmation below. She puts a child to do that. Incredible. I will adjourn our probable cause conference.
Bond revoked. Defendant remanded. The judge's message is clear. Actions have consequences. But there's a glimmer of hope. A probable cause conference in May. This is the defendant's chance to prove she's serious about change. If she fails again, jail is the only option.
May 14, 2026, 9 a.m. I'll also adjourn since there's no admission or anything regarding the bond violation. I'll adjourn the bond violation hearing to also that date. At this point in time, the defendant's bond is revoked. Defendant's remanded to the Washington County. Court calls the case. People versus Thomas.
Bring the government for the people here.
Brian Bowling on behalf of Mr. Thomas, judge, who is approaching. State your name for the record, please, Justin.
Justin Thomas.
Judge, when it comes to the the probable cause conference, I'm asking that we adjourn that. I'm still trying to get some discovery video specifically. And then I'm prepared to address what you're holding in your hands.
Yes, go ahead and address that.
All right. So he didn't report for the sober link until today. He has it currently right now. He went over to community corrections before coming here. The reason for him not having it before was that he was unable to pay for the shipping costs to have it sent to him directly. He has no resources financially at this point in time, Your Honor. But he does have it now. He lives in Pinckney.
St. Clair Shores.
Oh, I'm sorry. I thought I have an address in Pinckney. All right. He lives in St. Clair Shores. I'll have to get an updated mailing address for you.
Well, then he needed to find
Even better, I guess. But for my
right, but he needed to find a way down here. He doesn't get to.
And Mr. Thomas and I had that discussion, Your Honor, that
He's been released, and almost for a week, he
He did not have transportation to get here, Your Honor. It was a
walked by that time.
It was a very difficult situation getting him here today once the Zoom grant was revoked. But he did make it here today. He has the sober link. He did test at community corrections today. To my understanding, that was negative. And he's prepared to comply with this court's bond order for purposes of testing moving forward, Your Honor.
Well, it can't work. This wasn't even just an issue of not having the shipping. He wasn't calling people back. He wasn't completing his whole intake.
We did complete, to my knowledge, Your Honor. He wasn't returning calls. Again, like I said, Mr. Thomas and I discussed that. I don't expect the court to have any further problems with him at this point in time. He does have the device. He's holding it here. You got to return calls when people.
Why weren't you calling them back? I mean, I don't understand this.
He works nights, Your Honor. I think when he was trying to make the return calls, there was times where community corrections was closed. Again, that's something we discussed. There is a bit of may we approach briefly?
May.
Okay, thank you. Thanks for the bench conference, Your Honor. I have nothing further to add on the record at this point in time. Like I said, based on him having the sober link now, I would ask the court to continue his bond and then new probable cause conference date, or will be so willing.
Probable cause conference will be set for May 21st, 2026, 9 a.m. At this point, since he's on it, I'm not going to do anything.
A second chance for Justin Thomas. Sober, link in hand, negative test, and a promise to comply. But the judge's warning is a steel trap. One missed blow, and there's no mercy. This is the kind of moment where defendants either turn their lives around or dig their graves deeper.
But I want you to understand something, young man. If you miss one blow, I'm not hearing any uses from it.
Oh, no.
Am I clear?
Yeah, it's pretty clear.
Bond will continue.
Thank you, Judge. Outside real quick, I want to get that new address.